Good afternoon. I'm Russ Feingold, President of the American Constitution Society, the country's foremost progressive legal organization. We have more than 250 student and lawyer chapters across the nation. And ACS's mission is to shape legal debate, nurture the next generation of lawyers, judges, and advocates, and ensure that the law is a force to improve the lives of all people. If you are not already, I'd encourage you to become a member of ACS. Go to acslaw.org, where you can join ACS and find more information about events like our upcoming national convention, June 16th through the 18th, in person, here in Washington, D.C., but also virtually. I'd also encourage you to follow ACS on social media, including on Twitter at ACS Law. Just some quick housekeeping notes before we begin. Today's discussion is being recorded, and the recording will be available on ACS's website after today's program concludes. 1 hour of California CLE credit is available for today's discussion. Additional information and CLE materials can be found on the event page of the ACS website and will be shared with all participants in a follow-up email. So I'm pleased to welcome you to today's program. Supreme but not immune, creating a binding code of ethics for Supreme Court justices. The proverbial elephant in the room that has prompted us to have this conversation now is political consultant Ginni Thomas's role in the January 6th insurrection and her husband, Supreme Court Justice Clarence Thomas's decision not to recuse himself from cases related to the insurrection. This is an egregious ethical lapse, given the Thomas's close connection as spouses and the existential threat to democracy that the insurrection and its defenders represent. Unfortunately, ethical lapses by the Supreme Court justices are not entirely new nor limited to ideology. Some justices have participated in cases in which they held stock in one of the party's companies or had personal relationships with one of the named parties. Some have appeared at political fundraisers or signed multi-million-dollar book deals. Some have failed to make public their reimbursements and gifts in their annual disclosures. So beyond the potential embarrassment of being called out publicly, there have been no consequences for these lapses in ethics. The Thomas scandal is drawing attention to this fact and the fact that the code of conduct for United States judges and its ethical canons explicitly do not apply to Supreme Court justices. So today's discussion will examine why that is, what can be done to provide greater accountability for these ethical lapses and the constitutional limits on congressional and judicial efforts to create a binding code for ethics code for Supreme Court justices. So with all that, it's now my pleasure to turn it over to our moderator for today's discussion, Senior Legislative Counsel at Alliance for Justice, Kimberly Humphrey. Kimberly?
Hi, can you hear me? Great. Thank you so much, Russ. Thank you for having me and welcome to everyone. This is an important, very timely conversation as described. And so we are eager to get into it. But before we do, I'd like to note that there will be a Q&A a little later. There is a Q&A box where you will input your questions as we go through the conversation. And we will get to those, like I said, later after some of our initial discussion. So we know that these issues have been percolating for some time. I do believe that it has gotten to a point that it can't be ignored. And I do like the use of the term scandal. And it seems that maybe if we used that term more often, we might see much more swift movement on really balancing and creating a standard that seems appropriate at this time. So today for our discussion, I am joined by Professor Veronica Root Martinez. She's professor of law and a Robert Merriam Short Scholar. She's the director of programs on ethics, compliance, and inclusion at the University of Notre Dame Law School. Thank you. Second, we have Mr. Louis Farrelly, professor of law at Stenson University College of Law. So, first, I'm going to start by allowing our distinguished guests to just take a minute to give an introduction of their backgrounds and the types of things they work on, and then we will get further into the discussion. So I'll start with Ms. Martinez.
Hello, thank you so much for having me here today. As Kimberly noted, my name is Veronica Root Martinez, and I'm a professor of law at Notre Dame Law School. I'll be joining Duke Law School this summer. I research issues related to professional ethics and organizational ethics. And so I've long thought about what sort of structures and incentives you should put in place so that individuals act in an ethical manner. And I think that's what's most relevant for today. So thank you so much for having me for the discussion.
Sure thing. And Professor Farrelly.
Hi, thanks for having me. It's really an honor to be here. I've been at Stetson for 15 years and have spent about 10 of those thinking and researching about Supreme Court recusal and Supreme Court ethics specifically. So I'm excited to be part of this topic. I never tire of talking about it. I'm also one of the faculty advisors and have been for a long time of Stetson's ACS chapter, which we're very proud of and is really rewarding. So it really is a pleasure to be here. Thanks for having me.
Wonderful, wonderful. And I should just add, I am, as I stated earlier, senior counsel for federal advocacy at Alliance for Justice, and we have a Building the Bench program that is very vital to all of our work together, and of course impacts the types of judges that we will have and the types of standards that we expect them all to follow. So first, I will leave this open to either of you to start, but we wanted to just kind of give people some context. So without getting into a blow by blow, can you tell us a little bit more about the context regarding Thomas's ethics concerns? And so you can just start there, and then anyone can follow up with other issues that have been percolating over the years. Thank you.
I defer to Veronica on this. I'm happy to follow.
Sure, happy to go ahead and start. So the crux of the concerns regarding Justice Thomas are related to whether he could have remained impartial in deciding a case where his wife's conduct is potentially at issue. So he chose to participate in one such case, so Trump v. Thompson from this past January. Supreme Court justices are not subject to many of the statutes and rules that other federal judges are subject to, but Supreme Court justices are subject to the disqualification rules. So for example, USC 455 says any justice, judge, or magistrate should decline to hear any matters in which their impartiality might be reasonably questioned. Additionally, the justice must also recuse if she or he has personal knowledge of a family connection to or financial interest in a case. So it's pretty unsurprising that many legal ethics experts who have opined on this issue on whether Thomas should have participated in a case believe that Thomas should have recused himself because it's difficult to imagine one being impartial in a case involving one's spouse. My own view, however, is, and I'm probably a minority in this particular room, is that linking the alleged conduct of the Thomases with the larger question of whether the Supreme Court should be subject to ethics rules or standards is a strategically poor decision. So there are good reasons for certain committees and members of Congress to inquire as to the nature of the conduct that took place regarding the Thomases. But the issue of whether or not there should be a code of ethics for the Supreme Court well predates any of the most recent allegations and shouldn't really be a big partisan issue, right? So this should be an issue that should be bipartisan. The Supreme Court has failed completely in adopting its own ethics rules. There are they've resisted on many occasions, and there are numerous examples, including this most recent one with the Thomases, but that go way beyond that, that suggest that this is just not tenable and can't continue.
Professor Barrett?
I'll just follow up with a little bit of larger Supreme Court recusal context. I think that might be where I have something to add. We'll find out, I guess. Veronica's of course right that the 28455 is the statute that applies to justice. It's applied since 1948. It did not apply for the previous 150 years of the statute's existence, or at least its predecessor's existence. 1974 was amended to sort of change some of the standards, make it a little bit more rigorous. But as I've written about before, the justices have never followed the statute. That's not in any way to comment on whether Justice Thomas should have recused himself. I have thoughts about that I think we can talk more about. I think it is really important. It's an important part of my view on all this, that the justices have since Marbury not followed the same recusal standards as everybody else. And there are reasons for that. And the problem with this conversation historically has been that there are decent reasons for that. They just may not be good enough reasons to justify each individual decision, right? So the Supreme Court is not the same as other courts when we talk about recusal, and we can talk about why. And they have never used that statutory standard like a binding statutory standard. Even the three examples we have of the Court of Justice explaining their decisions not to recuse, we really only have three. 1972, Justice Rehnquist, at the time, Justice Rehnquist, not Chief Justice yet, Justice Scalia when he went duck hunting, as we all know, and Chief Justice Rehnquist when his son's law firm appeared before him in the Microsoft case. All three of those cases have long explanations of why those justices didn't recuse, and all three of them are not statutory analysis, right? They are pragmatic, policy-based decisions that we can absolutely talk about whether or not they were right or wrong, separate issue. But there is a problem with sort of with trying to create legal standards for the justices. And I agree with Veronica. I think maybe we're both in the minority here. My reasons for thinking a code of ethics is problematic is not strategic as much as it is symbolic. Right? I think we have a better avenue for holding justices accountable for reasons I guess we can get into. But that's all I would add.
Sure. So you did name a few different examples, but in addition, are there other ethical lapses or concerns that people should be worried about? And I think I'll start with Professor Martinez here.
So there are a lot of issues that people should be concerned about when it comes to Supreme Court ethics. I think the ones that people go to immediately are concerns regarding conflicts of interest and whether or not the justices are appropriately analyzing whether or not they have a conflict of interest. There are all sorts of industries that have robust conflict of interest rules. The legal profession has robust conflict of interest rules. And so right now what we have is a system where the justices basically say, hey, we're good people, you should just trust us to be able to evaluate these conflicts of interest on our own. And that view, my view is that that's an arrogant position to take, right? So the idea that I'm always going to analyze things in the best way possible when it's not necessarily in my own interest is just not in line with scholarship that looks at just regular human decision making. In addition to conflicts of interest, I mean, you can just look at the code of conduct for U.S. judges to see kind of what it is that has been focused on in the past that you would be concerned with the federal judiciary. So this code of conduct applies to all judges, all lower federal judges, and not the U.S. Supreme Court. So, Canon 1 says a judge should uphold the integrity and independence of the judiciary. Canon 2, a judge should avoid impropriety and the appearance of impropriety in all activities. Canon 3, a judge should perform the duties of office fairly, impartially, and diligently. And then a judge should refrain from political activity, and a judge may engage in extrajudicial activities that are consistent with the obligations of judicial office. So there's these 5 canons. And we can come up with examples, I think, of ways in which people are concerned with the behavior of Supreme Court justices. Sometimes a Supreme Court justice will go and give a speech somewhere, and then you'll end up with news articles that are essentially about, is this violating the appearance of impropriety? Sometimes people are concerned that the justices are not properly recusing themselves and they have maybe like a financial conflict of interest. Again, that would raise the issues related to uphold the integrity and independence of the judiciary. So I think the code of conduct provides a framework for thinking through what are the sorts of issues we might be concerned with for Supreme Court justices. But I think at the end of the day, where most concerns have to deal with potential conflicts of interest, and are they recusing when they should?
Right. And I appreciate you going through that for our audience. And I think one of you may have mentioned it, but can you also just share a little bit about why Supreme Court justices are exempted from those canons and codes you just went through? And we can start with Mr. Bradley.
Yeah, yes, I can do that, and I can be corrected where I come up short. The Code of Conduct, it does not apply to the Supreme Court because it's adopted by the Judicial Council. The Judicial Council is created by Congress and specifically not given authority by Congress to do this. The sort of common wisdom as to why that's true is because lower court judges ostensibly cannot regulate the Supreme Court. The judiciary is the branch of government that has a hierarchy built into it, right? The Supreme Court is supreme. Therefore, all the other judges in that branch are not of equal authority when it comes to regulating the Supreme Court justices. So we've operated under this system for a long time. That's not to endorse it, right? But I think saying the judiciary is hierarchical and that at some point the ability to regulate Supreme Court justices cannot be held by lower court judges is at least understandable and something we've operated on for a long time. And that's why Congress made that choice. I'll leave it at that.
Great. Do you have anything to add, Professor Martinez?
I would just add that, so the Code of Conduct itself, so you can have, so there's basically two issues. So do you want to have an ethics code? And then how do you make the ethics code enforceable? So the Code of Conduct for the lower federal courts becomes enforceable because of the Judicial Conduct and Disability Act of 1980. And that, again, only applies to the lower federal courts. So if you violate the Code of Conduct, you could end up having a complaint filed against you under the Judicial Conduct and Disability Act. And then there's procedures that go through. And so I'll just add that little piece. Like, you can't, it's not just about, do you want to have Supreme Court ethics rules or standards? You would also then want to have some sort of enforcement mechanism. So like Professor Borelli is saying, like with the statutory context, we have a statute that does formally apply, but if you don't have an enforcement mechanism, then one question you might have is, why should they comply if there's nothing there if there's no consequence?
Can I just add, and I think that last sentence, if I don't want to jump the gun, Kimberly, but that last sentence sort of inspires me to add, and it's why should they comply is the right question, I think. And that's what I think is frustrating to folks. But I hinted before that the Supreme Court's different, and it's different in a really important way. And here's how. Supreme Court justices are not replaceable. So when you recuse when a Supreme Court justice is recused or recuses themselves, it changes the number and makeup of the court. And therefore, you have a different institution. Now, that could be overly dramatic, right? Depending on the nature of the decision and whether anybody in America cares about a given Supreme Court decision, which is often not the case. But it is true that when a justice recuses, it changes the nature of the court. And the justices have been saying in testimony before Congress and in their written product about the topic in the 2011 year-end report of the federal judiciary from Chief Justice Roberts, the 1993 recusal statement from the court, that they are keenly aware of the idea that recusal is a way that of influencing the outcome of a case potentially. And therefore, there's an additional layer of consideration that Supreme Court justices have to go through when they recuse that lower court judges do not. And that is are the ethical benefits of my recusing worth it institutionally? So the example that has come up most frequently, or at least in the last 5 years, we can recall Justice Ginsburg's comments about candidate Trump, which I wholeheartedly supported, but that's an aside. The question then became if there's a lawsuit over the election, if there's Trump v. Clinton, can Justice Ginsburg participate? And of course, I said yes. I had lots of opportunity to talk about it at the time. And the reason I said yes was because the institutional concerns about having a tie vote over who is president, and therefore letting a circuit court of appeals pick the president of the US, was intolerable compared to whatever ethical concerns we might think attached to Justice Ginsburg's comments. That balance is only true at the Supreme Court. So when we talk about what a code of ethics would look like, it would have to incorporate that balance, or at least anticipate that balance. And I am of the view that that balance would cause the code to be so watered down that we'd be wildly unsatisfied with it. And my view is, and I'm currently working on an article to this effect, it would end up being counterproductive, because we would have a code that, even if we thought were enforceable, per Professor Martinez's point, we wouldn't like what it said, and we wouldn't understand how it's going to apply in advance. It would be a case-by-case decision that would be wholly unsatisfying, and in my view, would make all the branches involved look ineffective. Now, I have a proposed solution, but I've been talking for too long.
Yeah, let me interject there, because it's an interesting conundrum, right? The Supreme Court is the highest court. However, we are consistently at this point seeing serious issues that bring about a questioning of the legitimacy and the public trust in the court. So with that being said, we also don't really, we would think that judicial and ethical and controversy, excuse me, wouldn't really go together in the same sentence if it was the case that the Supreme Court is so different that we really essentially need to keep our hands off. So that just brings me to the point of kind of, how do we move forward? How would we have some type of operations or checks and balances? I'll leave it there. Is there anything we can do? And I'll start with Ms. Martinez.
So I think there's a variety of things that can be done. So first, the Supreme Court could choose to create its own self-regulatory mechanism. So one of the hallmarks of a profession is that it regulates its own members. So this should be familiar to us all. We're members of the legal profession. We self-regulate. We have a disciplinary system. We discipline ourselves, and all of that is there. The Supreme Court isn't even doing that. The Supreme Court has said, you should just trust us. We don't even need to self-regulate. We'll just deal with it all on our own. That to me doesn't make a whole lot of sense, because if you ask somebody, well, could you impartially decide this? They're going to think the best of themselves. They're going to think, of course, I'm going to maintain my own standards of ethics. But behavioral ethics literature tells us that we all fall short, all of us, myself included, in making those sorts of determinations. So the Supreme Court could choose on its own to adopt some sort of self-regulatory mechanism to deal with issues that commonly appear before the court. And the Supreme Court could choose on its own to create some sort of enforcement mechanism. And as long as the Supreme Court is doing it on its own, I don't think we fall into any of these constitutional concerns that are often raised as red flags whenever Congress passes a statute, proposes a statute that would look to regulate Supreme Court ethics. So the Supreme Court could choose to do that. And I think it's important to remember that when you fail at self-regulation, it is very common for the state to intervene. So after Enron, WorldCom, attorneys were involved in certain circumstances that suggested that attorneys weren't properly engaged in gatekeeping activities. Congress passes the Sarbanes-Oxley, and Section 307 is targeted directly at lawyers. We saw a more recent example a couple of weeks ago in the state of California, where there were concerns that the California bar wasn't properly looking into claims of potential misconduct of attorneys. So the California legislature says, you know what, if you're not going to do it yourself, then we're going to order an audit. And they ordered an audit, and the results of the audit was that the California bar is not properly engaging in oversight of attorneys. And we'll see what they do next. And so I really like the model of the Judicial Conduct and Disability Act for a variety of reasons. But one of them is that it is a statute that Congress has passed, but it essentially tells the judges you need to engage in self-regulation. So the judges administer the discipline themselves, the judges do the investigations. It's not perfect. I mean, I've written criticizing that act. It's not perfect, but if the Supreme Court keeps insisting that you should just trust us, and we've seen this in statements from Roberts in 2011, in 2021, at some point the state needs to intervene. And the state at this point is Congress. And the most modest intervention would be, I think, you need to do something. But if the Supreme Court wants to avoid any of that, all it needs to do is decide what sort of code of ethics it wants to put in place for itself and what its enforcement mechanism is going to be. But it can make those decisions for itself, and then we can play it out and see how it goes. But right now, they're not even doing that. They're just saying, hey, we're great, just trust us. And I just don't think that that is a sufficient response at this moment in time.
And I will give you an opportunity, Professor Varelli. But I do want to just remind people that not only has this been in the media, but Congress is taking steps to look deeper. Just last week, they had a hearing called The Need for a Supreme Court Code of Ethics, just delving into these topics and some of the concerns outlined just a second ago. And actually tomorrow, the Senate will have a similar hearing. An ethical judiciary is the title. It's looking into the transparency and accountability for 21st century courts. So I just wanted to put that into the conversation as well, because it's actually something that's being considered at this moment. And I also wanted to give our other panelists an opportunity to add about your thoughts about this legislation and what should be done, especially when we see that there has been an opportunity to take action, and they've had that opportunity for a while, and we see that there has been inaction there.
So I'll pick up there. The most recent bill that was, I think it was April 6th, was introduced by both houses, is the 18th by my account since 2011, addressing some version of a code of conduct to the Supreme Court. None of them have come to fruition, but you're right, this is something that's going on for a long time. To build on what Professor Martinez said, let me first start. There's a question in the chat that I think might be on people's minds to the point where it could be distracting, and that was, if Martinez and Varelli agree that justices are not recusing themselves when they clearly should, why isn't that reason enough to impose a code of conduct? Well, I mean, I don't want to speak, I will not speak for Professor Martinez, but my position is not that they are regularly failing to recuse themselves when they clearly should. I don't know that. Part of the problem is that we don't know that, which is a separate question. But the justices do recuse themselves pretty frequently. In terms of, there's multiple annual recusals. They're overwhelmingly financial, and they're overwhelmingly based on stock ownership. But for example, Justice Barrett is recused from cases she sat on in the Seventh Circuit, and Justice Kagan recused from cases she saw while Solicitor General. These are all very common features. So, and I'll speak for only myself, I don't view this as an epidemic. I think there are problems in high-profile cases based on a more high-profile judiciary, frankly. The justices are out and about more, I believe, Kimberly, as you mentioned. And we're hearing more from them, and that's a problem. And I agree that that is a problem. But to the points Professor Martinez made, and I think she's right, we are of a similar mind here. I would point out that I think there are real constitutional problems with anybody but the court regulating this in a legally binding way. And I wrote a book to that effect in 2016. I think any legally binding recusal standards, for example, from another branch of government are unconstitutional because they could effectively remove the court from a case in its entirety, right? If you could create a standard where all 9 justices are recusable, then there's no Supreme Court available, then Congress has interfered with the functioning of the judiciary. We can talk about whether that's reasonable or worth talking about any further. But as for the court adopting its own, I agree 100% that's permissible. And it could work. The problem is what the second question raises, and I'm just repeating the justices here. Justice Kennedy described reviewing his own colleagues' recusal decisions as lobbying, right? The justices won't. Now, they may be wrong about that, but I feel pretty confident that based on the last decade or so of testimony and writing that Professor Martinez talked about, the justices won't review each other's decisions. And part of it is because they don't simply want to be involved, which I think is not necessarily a laudable goal. But it's also because what the questioner raises, that they don't want to appear like they're changing the nature and number of the court in a given case. What we will end up with is an ethical fight about the ethical fight that might be better than nothing, or than an individual justice making their own decision. But But my view has been, and I will promise to stop. I will just say this. My view is that the best way to do this is to focus on the due process clause, and for sort of the equivalent of public shaming, right? Where instead of saying a justice did or did not follow a particular legal standard, the justice is just wrong and being unethical. See Justice Thomas, if he sits on a case involving his wife, because we have a legally binding standard. We don't need another one. 28 U.S.C. 455 is legally binding. It just doesn't work and never has. The justices won't enforce it against themselves because they don't want to be seen to be picking and choosing. And I don't know that we can do any better than that in terms of coercing them. Now, I'm not intending to be defeatist, but I think my view is that talking too much about a code is a distraction, in the sense that it has us focused on things that will not get us where we want to go. And to answer Professor Morrison, whose work I'm familiar with and respect very much, yes, that's exactly right. The thesis of my book is that 455 is unconstitutional as applied to the Supreme Court.
So,
if I could
Professor
just interject.
Martinez, yeah,
So-
can we do better and
So I think we
go
can.
on with your point?
So I think we can do better. So the problem, one of the problems with 455, as Professor Varela just put out, is that there's no enforcement mechanism, right? So the Supreme Court could say, we're going to adopt a code of ethics, and for civility reasons, we do not want to be just making decisions about each other's recusal standards. And so instead, we are going to impanel every chief judge of every circuit, and they will review the recusal decisions. They can make up whatever they want, right? But it's really important that whatever is created has some sort of objective enforcement mechanism. If the justices are continuing to refuse to do that, I mean, they can literally do anything. And I'm sure other professors and members of the bar would happily volunteer to help structure some sort of code of ethics for the Supreme Court. But if they say that they're not willing to, the state has to intervene. It is not tenable in this day and age, in part because of just the differences in media exposure and social media, and our ability to track what the justices are doing. It is eroding the legitimacy of the court for people to continue to think that the court is increasingly partisan. And whether that is or is not true, the lack of an ethics standard is contributing to the belief of the public that the court is just a partisan show that isn't actually putting out objective and legitimate decisions. And that is bad for the rule of law, and it is bad for the country. And so if the court continues to refuse to do this, Congress has to do something. The most minor thing, the least obtrusive thing that Congress could do is to say, Supreme Court, you need to adopt your own ethics standard with an enforcement mechanism. Do whatever you like, and then see what they do. And if they, this is likely going to be a lot of back and forth and this, that, and the other. But the idea that Congress can do nothing when Congress does have the power, there are scholars who have argued that there is power and legitimacy for the court to intervene and for Congress to intervene in different circumstances based off of just the Congress. So I think Gay and Gillers in 2013 said, the U.S. Constitution delegates to Congress the powers to regulate the court's appellate jurisdiction and to make laws necessary and proper for carrying into execution. All powers vested by the Constitution and the government of the United States. Advocates of original intent might note that the founding generation interpreted those powers broadly to permit Congress to regulate the size of the Supreme Court, where, when, and how often the court meets, how many justices constitute a quorum, and the duties of the justices themselves. So including a duty to ride circuit and hear cases as trial judges. So legislation requiring the court to write its own code of ethics falls well within this congressional power. Congress has a lot of power, right? Like there's been Biden just finished having a bunch of scholars and other individuals engage in this review of the Supreme Court and what can and cannot be done. The Supreme Court is not I don't think it's correct to say that there's no way that you can engage in some sort of oversight of the Supreme Court. I understand that there are separation of powers concerns. I do think that those concerns were delicately handled in the Judicial Conduct and Disability Act for the federal judiciary more generally. But the idea that Congress can do nothing, that's hard.
And can both of you, if you want to take a moment and just talk a little bit more about those separation of powers concerns, just so that it's very clear for all who are listening.
If it's okay, Professor Martinez, because I think I agree with you. Congress can do, my view, Congress has things they can do. My view is they're overwhelmingly sort of procedural and transparency based, right? So they could require that the court adopt a code. I don't know what they would do if the court refused, but they could require them. I don't know how they would make them other than to withhold funding, which they can do. My view about that code is that because of the nature of the balancing I was talking about, that code would look so vague and flexible that it would be wildly unsatisfying, even if the justices did their level best. I'll remind everybody that 455 is enforceable, right? It's enforceable by the courts. Just the problem is there's no court to enforce a perceived failure of the Supreme Court, right? So the justices could agree on an enforcement mechanism. Whether they would agree to have the 13 chief circuit court judges tell them to recuse, right? I mean, I agree with you, it's legal. I don't know that they would do it. And then the separation of powers problems for me are reasonably simple in my mind. The court's responsibility, the judicial power, which Article 3 gives them, scholars generally coalesce around at least this very minimal view of what that means. It means the power to decide cases properly before them, right? So if you have a case, you have judicial power, you have the power to pick a winner in a case that you have jurisdiction over. If you have a legally binding recusal standard, you could create a legal requirement that the court not be available to sit. That would deprive either deprive the country of one Supreme Court or deprive the court of the judicial power in a given case. That's unconstitutional. It does not mean that the financial disclosure requirements are unconstitutional. It does not mean requirements that recusal decisions be explained in writing are unconstitutional. I think all of those things are allowed. I'm skeptical about how they will go. And my concern is not that I don't think they're necessary or useful. My concern is that if we try and fail again, I consider the recusal statute a failure, right? Because the court doesn't use it like a statute. If we try and fail again, it just makes everybody look even worse. What are the ways to focus the public's criticism more directly on the individual justices?
So, well, along those lines, what about, to Professor Martinez's point, if we actually saw action, right, more people might be lined up with you, Professor Borelli, that, hey, they can do and act and should act on their own behalf to protect their future decisions. But what about a timed procedure? If Congress puts something in place, you have to act in this time, and we still don't see action. Do we think that the implications for inaction or the implications for just continuing to see the breaches and the conflicts go on unaddressed, where does that leave us if we don't see anything? And do you think it's worth it to just have that opportunity? And would you be in agreement to do something if they did have that opportunity and still didn't act?
I don't want to jump the line, but that was to me.
Yes.
I think I am a pessimist about the fruits of that process, right? So if Congress were to set a time, first of all, they do that with agencies all the time, right? And agencies who are much more beholden to Congress than the Supreme Court don't meet those deadlines. But if the court did it, I think it would look a lot like the code of conduct, perhaps. And then the justices would continue to make decisions the same way they do. And to the extent that they're being unethical, then I don't think there'd be any less inclined, right, to be unethical later. But more to the point, I think that code has got to accommodate the fact that the Supreme Court makes recusal decisions by necessity differently, right? See the Trump v. Clinton example, see the Affordable Care Act, right? Was it more important to have the largest healthcare reform in 80 years be reviewed, or 50 years be reviewed by all 9 justices, or for Justices Kagan and Thomas to be recused because one was Solicitor General when the case went through the DOJ, and Justice Thomas's wife made $750,000 advocating against the act? They may not be equal ethical challenges, but we are starting to see calls for recusal in almost every important case. And I wonder if those calls will be any less if there is a code of conduct that is context specific, that the justices will almost certainly treat the same way they treat the current recusal statute and the code that doesn't apply to them.
And Professor Martinez, so on that point, you can feel free to add to, but also the polling shows, and I think to your point earlier, just about public trust in the Supreme Court, that a lot of Americans would be in favor of seeing a code of conduct for the highest court in the land. How do we make this happen? How can we move forward?
So I think I have a few thoughts. First, I think I am skeptical that shaming of the justices is going to change their behavior. And in part, that's because of the rise of social media. And if you go onto social media and you put in any justice's name, you're going to get a litany of terrible, terrible, awful, horrible things being said about them all of the time. And so I don't think you can be a Supreme Court justice right now without choosing to ignore a lot of the commentary about you, because some of it is inflammatory, a lot of it's not legitimate. And it's like, so I don't really see how public shaming is going to work in an environment where we're shaming people in ways that aren't legitimate. So there's that. I would agree that there on the calls for recusal point. Sure, there are lots of, and I'm going to call them unsophisticated calls for recusal in every case. Now that must be a conflict of interest, like, so therefore you should recuse. I think that the Supreme Court is smart enough to develop a recusal standard that can be enforceable, that is sophisticated, that understands the special place the Supreme Court holds, while also understanding that it should not be in the decision-making authority of the individual justice to decide whether or not they do or do not have a conflict of interest. That is putting too much pressure on an individual to always make the right choice when individuals do not always make the right choices. In terms of public opinion, I do think that if the Supreme Court were to adopt a code of ethics and that it would have some sort of objective enforcement mechanism, objective ways in which it operates, it would help to quell this idea the justices can just do whatever they want and they're above the law. And that is part of that's part of the rub, I think, right now, in the public's perception of what the Supreme Court is, what the justices do and do not engage in right now. And so I don't think it's necessarily the case that a code of conduct has to, I do not agree that a code of conduct being adopted would necessarily be toothless. I think it depends on what is adopted, how it is adopted, what its enforcement mechanism looks like. In terms of the recusal standard, there would need to be some sort of solution, right? There would need to be some sort of solution, mainly so that there isn't gamesmanship in people requesting for recusal, because that to me is the real fear. Because the Supreme Court adopts a recusal standard and then litigants start trying to game that recusal standard. And so I do have thoughts on like different ways you could get away around the gaming, but that to me is the real concern that the Supreme Court would have legitimate fear of, that individual litigants would start trying to game the system. I mean, back when I was in law school at Chicago, I don't know if the Seventh Circuit still does this, but the Seventh Circuit didn't announce who your panel was going to be until the day of argument. And it was essentially because litigants started gaming the arguments in their briefs based off of the panel that had been announced. And so then they took away that ability to engage in that gamesmanship by announcing the panel the day of. And so, the justices are really smart people. I believe that they could figure this out if they were so inclined. And if they choose to keep ignoring it, if we keep getting reports from Chief Justice Roberts that say, I know it's an issue, but really it's okay, it should be fine, then at some point the state has to intervene. It is not acceptable to just keep saying, well, we're fine, we'll do it ourselves.
Thank you. And I think that is a great place for us to take some time to respond to some questions. I think both sides here, although not completely in disagreement, have clearly outlined some possible next steps and what might be fruitful, not only for the Supreme Court, but for the country and for the protection of the appearance of justice, and to make sure that we don't allow conflicts to just go unaddressed. So there is a question here that I think is worth broaching upon, just because it's offered by a student, and these are terms that we often hear in the dialogue. So it might make for an interesting discussion, and I may add a few points at the end as well. So Mr. Samad says, I'm a law student. Please elaborate about judicial activism and judicial philosophy. And either one of you can start.
I'll take a crack at it if nobody minds, I guess. Well, I tend to be one who thinks that judicial activism is a word that is almost devoid of meaning at this point, right? It means a judge doing something that we think is not worthy of the robe, so to speak, is not worthy of the office. It's moving the law in a way that is somehow inappropriate for a judge to do. And judicial philosophy, as I get older and grumpier, I find to be less compelling also, right? I mean, I think it's something we focus on a lot. It has been the touchstone of recent Supreme Court hearings, and frankly, all the Supreme Court hearings in my lifetime. And I think it is meant to reflect how a judge approaches cases. Now, of course, this applies differently to the Supreme Court because lower court judges are bound by, and I think generally speaking, feel bound by Supreme Court precedents. Supreme Court justices increasingly feel less bound by their own precedent, which I think is a real crisis at the court. So in that regard, philosophy has become a touchstone for ideology, a code word, a buzzword for ideology. And I think one of the biggest problems facing the Supreme Court today is that ideology is becoming a more brazen part of the adjudicative approaches of the justices. The justices are becoming less shy about exercising their ideology in their decision making, and that makes me very, very nervous.
Yeah, I don't really know that I have much to add. So I guess I think of judicial activism as a judge moving beyond the bounds of law, and I'm deciding something more than the question before them. And so that's probably kind of a narrow definition. And in terms of judicial philosophy, many of the justices have kind of intellectual frameworks through which they make their decisions, right? So, and so they kind of put their intellectual framework on, look at the question, and then use that as a mechanism for making their decisions. But I agree that a lot of the judicial philosophy rhetoric today has really become a proxy for ideological preferences.
Thank you. I think that's spot on, and I agree. And do agree that, and I just want to make clear that I think that oftentimes it's not the subject of our, attorneys' conversations in the same way, because we know that those things should be separate. So it is often a buzzword for some of those politics that should be separate from the court, and the Supreme Court especially should be insulated from those things. So fun topic. We're just wading into just a tiny bit. We do have another question. I think we have time for maybe one more after this. I understand the criticism regarding the partisan nature of congressional hearings, but how long can or should Congress let the status quo persist? Maybe we'll start with Mr. Varelli.
I saw that Veronica had unmuted. I don't want to jump in line.
I didn't see that, and I just want to make sure I'm giving you both the opportunity to start. So either way.
I will turn this over very quickly to Professor Martinez. My view is that Congress is the wrong place to look, right? That we should be using motions under the due process clause and sort of a more realistic approach. Realistic is too strong. I don't mean that. A realism approach to say the justices are going to have to regulate themselves. And the best way for us to do that is public pressure on individual justices for behaving in a way that we think is unacceptable. I don't know how promising that is, but I think focusing on Congress has not worked since 1948 and is not likely to work any better.
So I think Congress should act now. I think it becomes more difficult. I mean, so I think that there was some momentum going on. I'm not going to say the name of the act correctly, but there's a new act dealing with providing kind of employment protections for judicial employees that's been introduced. I've written, and I think I've spoken to some people on the Judiciary Committee about making changes to the Judicial Conduct and Disability Act. So I do feel like there was momentum going towards the Supreme Court needs to have some sort of code of ethics, particularly because that would have been a much more moderate response than the sorts of things that were being proposed at the tail end of the last election in terms of Supreme Court reform, right? So in terms of like the gamut of things that were being proposed, like Supreme Court ethics would have seemed like relatively modest. And so I do think that there was an opportunity. I think the rhetoric around Justice Thomas, however, has created this kind of partisan blowback in a way that's making it more difficult to get to a bipartisan agreement that there should be a code of ethics. Because now what you're seeing is anyway, it's just, to me, it doesn't seem to be all that productive. And so, but I think Congress should act now. I mean, I think the Supreme Court has had plenty of time to do something. We have now 10 years worth of statements from Chief Justice Roberts saying that there's no need for this. And that suggests to me that there is not political will within the Supreme Court to engage in activities that the public needs them to engage in to reinforce the rule of law and democratic norms within our society.
And I think this will be the last question. Why couldn't the court decide to defer to a committee of the judicial conference? Because, and I think this is getting to, yes, on the recusals issue, because that does seem valid and a concern, and it seems a little like it may not be a huge problem if there are the right parameters around the review of recusal decisions. But instead of relying on the justices to make those decisions about each other that would lead to that lobbying that was mentioned, that seems like it could be possible. Why couldn't the court decide to defer to a committee on the judicial conference?
I think the court could. The court can do whatever it wants. It can create whatever enforcement mechanism it wants, and then there is no constitutional concern. So, I mean, there's a variety of things you could come up with, you could think up of how the court could create some sort of objective standard for reviewing recusal. So I think that they could.
And I would just add, I agree they could, but there wouldn't be any constitutional concerns with them agreeing to it, but I don't think any orders coming from that group of lower court judges would be legally binding on them. So they would have to be just complying, which they could do now, right? So I am the cynic, it turns out. But I think, yes, they could do it. Yes, it might be a good idea. I would support them doing it. I feel very confident they won't, but that's just me predicting. I've been wrong about lots of things recently, so I could be wrong about that. But I don't think you could take that order anywhere, right? I don't think there's any place to take a decision by lower court judges to wave it around and say, you have to follow this, for the same reason that the judges don't follow a statute that is clearly legally binding, right? I mean,
well, perhaps some of that public shaming that we talked about might come into use there. And so we are kind of closing or coming upon our last 5 minutes. So I'll ask each of you to add any more comments that you'd like to give in closing, just about the topic and how we move forward. perhaps. And also, I think this was mentioned, but it might be worth reinforcing or sharing your thoughts as you close out. What would an enforcement mechanism look like? I think both of you have kind of said what it could look like, but that it may not happen. So if you could just mention that again as we close out, that would be great.
So I'm happy to go first. I guess so I think that that the Supreme Court needs a code of ethics. I think we could get there in a variety of ways. I think the best situation would be for the Supreme Court to adopt a code on its own that includes some sort of enforcement mechanism. So what does an enforcement mechanism look like? It includes some sort of consequence. So or some sort of way in which to ensure that they comply. So let's say that they have a code of ethics that says that you need to recuse in the following situations. And there's a recusal issue dealing with one of the justices. And let's say it goes to a 3-judge panel of the Supreme Court itself. Professor Verley thinks they won't ever do this, but they could. They could have a 3-judge panel of the Supreme Court to review all recusals. And then their decision would be binding on the court per the court's rules. It is true that some of that a lot of what we're proposing, if it were to go up to the Supreme Court, like how do you make it enforceable? But how does the Supreme Court say, yeah, we know we've adopted these rules, and yeah, we know that this is what the rules say we're supposed to do, but we're just not going to do them, right? And I understand that part of Professor Verley's point is that that's what's happening under the statute right now, but there's no one actually calling them to task to say you're not following the statute in the way that I'm suggesting. The Supreme Court doesn't have an army. What makes what the Supreme Court says binding, right? And if they're not willing to adhere to rule of law norms themselves, that would erode the legitimacy of the court in an astonishing way. And then I do think shame might come in and stop them from engaging in certain activities. But anyway, I'll leave it there. Thank you so much for having me.
Sure. And last remarks?
I think I overwhelmingly agree. I think the court could do that. I am just, I think, skeptical, but I don't think I would certainly sleep well at night. I would suggest, and as a member of ACS, I worry about this, right? I worry about Justice Thomas's recusal being brought up before a panel of 3 conservative justices who all say, don't worry about it, right? Which they would, in my mind, because I believe they would. And then what, right? So it is very easy to keep saying no. So I know that I am sitting in a much easier position. Professor Martinez is doing all the hard work, and I agree with her that it can be done by people smarter than me. But I think my view, the message I try to send when I'm in this position to talk to people about this is to try to focus the blame where it belongs. I don't think the blame is in a lack of standards. I don't think the blame is in a lack of understanding. I don't think the blame is in not enough law. I think the blame is in justices who are willing to be fast and loose with their ethical obligations. And I don't know that we can fix that in a traditional legal way. So that's really where I'm coming from. And again, I'm very grateful for you having me. Thank you.
Sure. Well, thank you both for being here. I think it was an exciting conversation. Definitely something that we should continue and look forward to those next conversations. And I apologize for those who had questions that did not get covered. We will look for ACS and others to be creative and find other ways to share our thoughts about those topics. As we close out, I'll just say thank you for taking the time to be with us during your lunch break. I've enjoyed it, and everyone have a great day.